Well, it is a pleasure to be here. I would say probably since January of this year, there's been significant changes, both in terms of federal law enforcement efforts and as well as our state laws. And there's also some local policies and things we can discuss as well. So I really want to just acknowledge the Community College District for being proactive in terms of educating and equipping all of you that play some role here on this campus to ensure that the confidentiality and safety and security of the students and employees are protected. That is the purpose that I'm here today. I'm not here to get into political discussions or debates on immigration. That could be a heated conversation and take us in many different directions. So regardless of where you fall in the spectrum, my job here today is really just to present what the law is, provide some context in terms of the climate that we find ourselves today, and basically how for you to be best equipped to be able to handle a situation should Immigration Customs Enforcement visit the campus for one reason or another. So I want to give some context for our conversation first, so you can kind of better understand how we got here today. So a little over a year ago, President Trump signed the first executive order pertaining to immigration called Enhancing Public Safety in the Interior of the United States. This essentially is the executive order that lays out what the priorities are of this administration. So essentially, the priorities have been really not much different, I'll be quite honest with you, than what we saw under President Bush. And that's not to kind of give kudos to President Obama, because despite the fact that his priorities were different, he still, surpassed all presidents in terms of the rate of deportation and the number of people that were deported, right? So this isn't a political conversation. This is strictly kind of how policies have evolved and developed amongst different presidential administrations. So one of the main differences, though, I want to point out, and this is kind of a difference that has had a significant impact in our community, is prior, it's been a priority for Bush, Obama, and Trump to focus on individuals who have committed specific types of criminal offenses. Now, what we've seen in the past is generally people have to go through the criminal process, they're convicted, and that is the point in which immigration makes the determination as to whether or not they're going to initiate removal proceedings, also known as deportation proceedings against the individual. One of the biggest differences in this administration is that it is no longer necessary to wait for the conclusion of the criminal process. So anyone who has committed an act that constitutes a chargeable criminal offense, or if they're charged with any criminal offense, or convicted, right? So it's anyone who's committed an act, charged with an act, or convicted. We usually had to wait for the conviction prior. Now it's committed or charged is a priority for this administration. So why does that matter? It matters because there's a lot of people and students, I imagine, on this campus that may be here in a lawful status. They could have a H-1B, an F-1, a J-1, a variety type of student visas that allows them to study. Unfortunately, with this change, what we begun to see is that individuals, and it's for something that many people believe is a minor offense, but to give you an example, if someone is stopped for driving under the influence, we are seeing those visas being revoked before a charge is even filed in in criminal court. So we're having clients that have legal status, that those visas are being revoked, and it kind of creates a dual situation or problem for them. Now, we have a better chance of fighting the outcome of the case in the event that they're not convicted, but nonetheless, we are, as a country right now, under this administration, are very quick to apprehend and detain individuals for simply having committed an act. Another priority of this administration are individuals who have engaged in fraud or willful misrepresentation in connection with any official matter or application before a governmental agency. That could be anything. That could be someone applying for SSI, food stamps, welfare, any sort of public benefit or assistance. Individuals that have abused any programs related to the receipt of public benefits. And this is a really important point as well. But individuals who are subject to a final order of removal who have not complied with their legal obligation to depart the United States are also priority for this administration. So let me just talk about this point really briefly. It is not uncommon for individuals who have attempted to enter the United States, and typically from our land borders, to have been caught, apprehended, and then sent back. We generally find, I would say, the majority of these people traveling through our southern border of Mexico, although they're not necessarily all Mexican nationals. You'd be surprised by the number of people that fly into Mexico and attempt to cross our borders. If they're apprehended and placed in what we call an expedited removal process, meaning they're photographed, they're fingerprinted, and they're basically sent back, that legally and technically is a deportation. And a lot of people, and I imagine if any of the students on this campus have been apprehended or caught or stopped at the border and sent back, do not understand that they have been deported. And with that deportation, it impacts their access to due process, their legal rights. They do not have an opportunity to fight their case before an immigration judge. The federal government essentially can just reinstate that order and immediately remove the individual from the United States. So a lot of people may be here thinking, well, I've got a clean record, I don't have anything to worry about. This is something that individuals need to be concerned about. Right now, we've had clients that literally have no other violation but for this fourth point, meaning no criminal conviction, no other immigration violation. They were caught at the border, they came back, they had come back unlawfully. They are now being sought after, arrested, detained, and deported quickly. And these are cases literally from like 2003, 2004. Our record system isn't quite as reliable prior to 9/11, but pretty much you can bet after any apprehension after 9/11, probably late 2001, early 2002, they're in the database. And so those individuals can be relatively easily apprehended, deported, and removed. And I want to just make a point as well, again, because I know that there's a lot of different opinions and perspectives. I want to make clear that any violation of our immigration laws, and that includes deportations, are not criminal offenses, okay? So they are civil violations. So I want to just be clear here that any student on this campus that may have been subject to a final order is not a criminal. And so they're not to be treated as criminals. They should be given access to due process and to our court system and to our legal system. Nonetheless, they have reason to be concerned, especially in this time of high enforcement, because it is a deportation and they can be immediately removed from the United States. And it is a basis that we may find ICE coming on campus looking for a particular student because of this. And I'm going to talk a little bit about some changes in state laws that's made it a little bit more difficult for ICE to execute their efforts, but nonetheless, it's a real possibility, it's a real concern. And then lastly, in the judgment of an immigration officer, if the individual poses a risk to public safety or national security. So this kind of essentially establishes this is the focus of this administration. Now that does not say that anyone who happens to come in contact with immigration, that may not, none of these things may apply to them, is off the hook. So essentially anyone that does not have lawful status, and that may mean they came in lawfully on a tourist visa, on a student visa, on an employment-based visa, but have overstayed, they are exactly in the same position legally as someone who never had a visa and entered the United States. So anyone really that doesn't have legal status, who doesn't have a valid visa, who isn't a lawful permanent resident, or who isn't a US citizen, may be apprehended and subject to deportation. Okay, so that's something that this campus specifically needs to be concerned about, especially probably in programs like the English second language programs, other programs that might be open to the community that may serve a larger immigrant population. Another part of this executive order, just to mention briefly, and there are some slides that I have here that I'm just going to go over very quickly. I'm not going to go into detail about them for the purposes of our conversation today. But as another part of this executive order, the federal government is hiring an additional 10,000 immigration customs enforcement agents. Probably a lot of you have heard in the news about Trump working with some of the border states in trying to get the National Guard to be present. There's a lot more resources that are being expended, both by states and the federal government, to increase our enforcement efforts. So this hiring process has already begun. My concern about it is that they have lowered the requirements for agents to serve as Immigration Customs Enforcement, and we also are aware that there are people that work for the application side of the Department of Homeland Security that are given opportunity basically for overtime to be trained to serve two roles. And that's a little problematic for those of us who practice in this area because you don't know which hat they're wearing when. So just to give you, again, context, the Department of Homeland Security is broken up into 3 bureaus. One is our Enforcement Bureau, which is Immigration Customs Enforcement. The second one is Citizenship and Immigration Services. So they are the agency that basically processes all the applications, petitions, efforts for people to naturalize, to become lawful permanent residents, to be able to apply for asylum, temporary protected status, any immigration benefit. So that's kind of the benefit branch. And then thirdly, we have Customs and Border Protection. They are the ones responsible for protecting our seaports, our airports, and our land ports of entry. And then another focus of this executive order is to increase the participation in 287G program, which basically authorizes state and local law enforcement officials to perform the functions of immigration officers in relation to the investigation, apprehension, or detention of aliens in the United States. Again, to give you a little bit of history, the city of Anaheim here in Orange County was actually the first city in the country to engage in this memorandum of understanding with the federal government. This was probably about 18 years ago. And what resulted was the police department realized once they implemented this program, which essentially trains their law enforcement officers to act as federal law enforcement officers as well. And what they discovered was the areas of the city where there were a large population of immigrants in the community stopped cooperating with law enforcement in the reporting of crime and in helping with investigation of crime. It really made it very difficult for the police department to do their job. So they ended up doing away with the program after several years. But this program basically existed in different parts of the state of California. It still continues to exist throughout the United States. Because of some changes in state law, there is no law enforcement agency in the state of California that is permitted to participate in this program any longer. And we'll talk a little bit about, cities now having a problem with this legislation, which I will go into in a little bit more detail in a moment. So although this isn't applicable right now, there is a lawsuit that the Department of Justice has filed against the state of California, so we'll see kind of what happens in the future. Some other executive orders that this administration has signed. Again, we've heard a lot about media wanting to construct the wall, detaining people. They're detaining people at an unprecedented rate, both at land borders and within the United States. I think President Trump has far surpassed the apprehension and detention of individuals than Obama certainly ever did, although we have yet to see those numbers result in the deportations as of yet. A focus in enacting federal-state partnerships to enforce federal immigration laws, expand detention facilities and courts for these facilities, and hire an additional 5,000 Customs and Border Protection agents. And there's a lot of changes that we're seeing with our immigration courts. They've established quotas that judges need to meet in terms of how quickly they process these cases, which again has impact on applicants, especially if they don't have evidence readily available and they're fleeing their country and have a fear of persecution. So it's having its impact, and they're really increasing the resources that are being made available at the border to process individuals much more quickly than ever. Okay, so that kind of gives you some context where we are federally. Now I want to take a moment just to talk about where we are here in the state of California. So just to be clear, this part of the presentation is specific to California, so if anyone travels or goes Arizona, Texas, Oklahoma, New York, wherever they may go, this does not apply to them. However, in October, Governor Brown signed SB 54, which is called the California Values Act, In the media, we've heard it usually referred to as a sanctuary state bill. It went into effect January 1st of this year. And essentially what it does, it bans state and local agencies, excluding the Department of Corrections, from enforcing holds on people in custody. So before, when someone was taken into custody for a criminal offense, and they were processed, and either they weren't going to be charged or their criminal procedures had been completed, a detainer would be held. So there would be 72 hours in which a sheriff's department or a local police department would hold an individual for purposes of immigration and allow immigration 72 hours in which to come and make a decision whether they're going to transfer the person to federal custody. So this law basically prevents that from happening any longer. Secondly, it blocks the deputization of police as immigration agents and bars state and local law enforcement agencies from inquiring into an individual's immigration status. So this is kind of referring to the 287G program that is no longer legal in the state of California. But it's also important because this impacts all state and local law enforcement agencies. So law enforcement, local police officers, sheriffs are not able to inquire into an individual's immigration status. So we would often find before law enforcement officers essentially taking matters into their own hand, inquiring, and then voluntarily transferring them or driving them to San Clemente here in Orange County, that's where they drive them to basically turn them over to Customs and Border Protection. That is no longer lawful in the state of California. It also prohibits new or expanded contracts with federal agencies to use California law enforcement facilities as detention centers, although it does not force the termination of existing contracts. So speaking of here in Orange County, the county has a $22 million contract with Immigration Customs Enforcement. We have 2 facilities here in the county that's used to house immigrant detainees. Again, these are non-criminal immigrant detainees, individuals who are either waiting removal process or deportation proceedings, or being held for one reason or another. And those 2 facilities are Theo Lacey in Orange, which is right across the street from the block, and then Music, which is down in Irvine, otherwise known as the farm. So those facilities continue their contracts, they continue to house the immigrant detainees. Another kind of more current news I'll just mention to this point. We have several nonprofit organizations in the county that were accustomed to providing kind of know your rights presentation, educating the detainees in terms of what their due process rights are, how the immigration proceedings work, because unlike criminal proceedings, immigration proceedings the state or the government does not provide legal counsel. So there's no like equivalent to like a public defender's office. So the majority of immigrants are not able to afford representation and often go forward basically representing themselves. So the importance of these organizations to basically explain what the process is, how to plead, how to deny allegations, how to prepare your application was invaluable. As of yesterday, I believe, my days are a little blurred, it's either yesterday or the day before, the Trump administration has now halted any and all education programs in immigration detention facilities being conducted by any nonprofit. So that's going to have, again, another huge impact on the immigrants in detention and custody. I just want to say, if at any point you have questions about what I'm talking about, feel free to just raise your hand. I'm happy to make this as a dialogue because I think it's hard sometimes to wait till the end of a presentation and what was that question and what did she say and what was she talking about. So at any point, if you have questions about anything, feel free to ask. Go ahead.
Does this apply to 18 and over or does it apply to minors?
Okay, that's a great question. So his question was, does this apply only to individuals who are 18 years of age or older, or does it apply to minors? There is very little distinction made in our immigration laws between adults and minors. So I've represented children as young as 5 in removal proceedings that come unaccompanied. They're put through the same process. If you Google, there's some really interesting YouTube videos of what the government has done to create to try to educate the children on the process about court and who a judge is and how the questions are going to be asked, which is just disheartening to me because at the very least I feel like children don't have the mental capacity to represent themselves, but nonetheless they do often. So when we're speaking of apprehensions, detentions, the laws equally apply to minors as well as adults. I would say probably one of the major differences is that an individual doesn't begin to accumulate what we call unlawful presence in the United States until after the age of 18. And that matters if they're trying to legalize their status. That's the only reason why that matters. But otherwise, for the most part, it's the same for minors as it is for adults. Yes?
If they deporting an individual, do they give them time to gather their belongings? Or like, and then when they go to deported, where do they drop them off?
Yeah, so that's a great question. Her question was, when an individual is being deported, do they give them an opportunity to kind of get their stuff together, prepare to leave, and then where do they go? No, they don't. So one of my jobs when we do these community education presentations, which is not what this is to help educate and equip people in terms of how they can be prepared. They need to have a power, especially if they're one of those priorities, but even if they're not a priority, but they don't have legal status, they need to be prepared, because oftentimes they are taken into custody, they will not be released until they're in their home country. And so sometimes that could be a couple of days. If it's Mexico, it can sometimes even be same day. The further away the person needs to be taken back, the longer they will remain in custody. Some arrangements need to be made with the consulate of that country here, obtaining travel documents, flight availability, and to be able to put them back. So what's really difficult right now, again, with the enforcement efforts, we have clients that literally, there were programs in place prior to Trump that allowed individuals to check in. So they didn't have lawful status, but there were people from certain countries like Cuba, Laos, Cambodia, Vietnam, that the US did not have diplomatic relations with, so they could not deport them even if they wanted to. And so a lot of those relationships have been reestablished, but in the meantime, some of these individuals have literally been checking in with ICE on an annual basis for 15, 20 plus years. And this year, and I would say probably within the last 3 or 4 months, their check-in has resulted in their apprehension because now they can be removed. So imagine someone who has US citizen children, is now US citizen, spouse, that has a good job, that has basically, changed their life and a contributing member of society. They will be sent back. I had a client back probably a couple months ago from Cambodia who hadn't been there since he was 2. The mother was frantic. She says, I don't think he can even speak the language. I've got to figure out. So I was literally, my only role was to coordinate with ICE and the mom the date of the flight so she could fly back to be able to meet him, to be able to help connect him to whatever family or resources that might be available. So they have to deport the individual back to their country. They can't just kick them outside the United States to Canada or Mexico. They have to confirm the citizenship and nationality of the person, which sometimes can take some time, especially if they don't have a passport. Yes?
Since the immigration proceeding does not provide the public counsels or public defense for immigrants, how is it important for each city to have a legal defense fund to provide to local nonprofit organizations or law firms in order to support those immigrants? And how can, for your opinions, should each city propose a legal defense funds to support those immigrants who could not access to the legal defense, or some legal representation are out of reach because of the lack of resources?
Okay, so that's a good question. I'm going to answer your question, and then I'm probably, for the sake of time, I'm going to ask anytime afterwards. I'll stay here and we can have additional questions about things that may not be pertinent or relevant to enforcement, but I think it's a great question. So his question was, how important is it to have public counsel, or like the equivalent of public defender, resources available for immigrants in immigration court proceedings? And is there a value for local cities, for example, to establish a fund to assist with that representation? So this is kind of a very hot topic right now, especially, well, it's a very hot topic right now. I think it is extremely important for someone to have legal representation. I think that just, I mean, statistics across the board, regardless of the nature of the proceeding, a civil matter, a criminal matter, or an immigration matter, the outcome is significantly improved when an individual is represented. Any of you have been to small claims court or anything like that, it's nerve-wracking, and you can only imagine immigrants who aren't familiar with language, culture, process, how much more challenging that kind of system can be. The city of New York was the first city in the country to establish a city-funded program that basically ensures any indigent immigrant that is in removal proceedings be given legal representation. The most recent stats indicated that the approval rate of those cases in terms of successful outcome increased by 1,100%. So there's a lot to be said about immigration. You can look up stats, you can literally Google Executive Office of Immigration Review, which is under the Department of Justice, keeps all of the stats of every immigration court, basically outcomes by those represented, those not represented, and you'll just see the stark difference. So yes, it is incredibly important. The city of Santa Ana was the first city here in Orange County to actually commit funds to Santa Ana residents, again, who are low income. So it's not just for anybody. If you can afford an attorney, they're not going to give you resources. The Rivera Institute, those of you who are maybe familiar with them, essentially match those funds. It's for a period of 1 year. So we're very much in a test pilot program right now. The funds were given to the National Immigration Defenders Project, if I'm getting the name correctly. They're very experienced in representing individuals, and so they're working primarily at those two facilities, the Theo Lacey and the at Music, to provide that representation. It's too early. I think the attorney came on board like in November to really have any data yet, but there was recently a group of individuals that came together to create what's called the Orange County Justice Fund. And the purpose of this organization is going to be to raise money to sustain this program beyond the funding of the city and the Rivera Institute, because no one knows if they're going to commit even another dollar beyond the term of the agreement. So it does make a difference. To me, that's a political conversation probably within city councils and county board of supervisors. With recent action of our Orange County Board of Supervisors, I don't foresee that being a program that we're going to adopt anytime soon, but nonetheless, it makes a difference. I would certainly say that. Okay, so let me go ahead and continue. Another provision that was passed and went into effect this January is Assembly Bill 450, which is the Immigrant Worker Protection Act. And the only reason I mention this and why it's important is because sometimes ICE comes to a place of employment, and even though we're used to thinking this space as a campus really for students, there's, I'm imagining, probably hundreds if not thousands of employees that ICE is also interested in ensuring that the campus as an employer is complying with federal immigration law. So this is kind of a little bit different in terms of the priorities that I went over in that executive order. It doesn't have to do with anyone who is here unlawfully, that has violated any immigration law or criminal law. This specifically speaks to individuals and employers that are required under federal law to ensure that every employee is authorized to work in the United States. Okay, so all of you, because all of you are employees, I believe, should have completed the Form I-9 when you were hired. It has to be completed, usually on the first day. Documentation needs to be provided within 72 hours. So this bill essentially puts additional responsibilities and burdens on employers. Now, the only reason, like I said, I'm mentioning this is because, again, this is a context of an employment campus, and you don't know who ICE is going to come into contact with if they're here for this purpose. But essentially what this law does, it provides workers with protection from immigration enforcement while on the job, and imposes penalties from $2,000 to $10,000 for violating its provisions. So all of you as actors of the community college district and of a particular campus will be held, or the campus, I should say, or the employer will be held responsible if any employee violates this law. So it's important that you're aware of it. First, employers are prohibited from giving federal enforcement agents access to non-public areas without a warrant. And I'm going to go into detail about what a warrant is, what you should do, etc. But what's important for you to understand here, and I'm also going to go into detail in terms of what constitutes a non-public area. So just to be clear, because the funding of this campus is significantly received from government, it's considered a public space, right? But so is the White House. But that doesn't mean that the public can just wander anywhere they want throughout the White House. So again, even though this is a public school or a public campus, it doesn't give the right for Immigration Customs Enforcement to essentially have access to any area. So one of the tips, and again, some of the information it's going to be repeated, and it's only repeated because it's important. But one of the tips that I often give employers and schools is it's important to be clear about the spaces that are non-public and the spaces that are public. So if there's offices that belong to employees, or to have signs posted when possible, employee access only, authorized personnel, this is restricted area, whatever the case may be. But again, your job is to ensure that the documentation, documentation of students, confidentiality, safety, security are being preserved to the extent possible. There's other laws that come into place for schools, like FERPA, so you want to be extra careful that you're not being overly helpful. And that's generally where employers get into trouble. It's when there's a really overly enthusiastic, friendly receptionist that wants to be helpful and useful, and they guide immigration to a person that they're looking for, access to files, documents, etc. So if there's one thing, be friendly, but be careful and make sure that you're not providing unlawful assistance. So you want to make sure that unless they have a warrant, you are not giving them access to non-public areas. And I'll go again, like I said, public areas, we could mention, it would be like cafeterias, lobbies, waiting rooms, parking lots, open grass areas, where anyone from the public basically can come in and wander. Consider that the public space. If it's someone's office, if it's the HR department where there's personnel files, where financial aid, student services, anywhere where there's documentation or where there's space that students or the public are not able to access, that would be considered your non-public area. Not including I-9 notices of inspection, because I will talk about that briefly as well in terms of ICE can come on campus because they're investigating the employer. They basically have reason to believe that the employer is not complying with federal law, and they have the right to request all I-9 forms from the employer. So I'm not talking about that situation. Employers are prohibited from giving federal agents access to employee records without a subpoena or judicial warrant. So they can ask for whatever information they want. What you need to be clear about is how to respond and what not to give them. So unless they produce a warrant or a subpoena, they do not have a legal right to those documents. And if you have any doubt, I'm going to repeat, several times kind of the protocol that Arturo mentioned in the beginning. Contact campus safety or contact human resources, the Vice Chancellor's office, to make sure that you're not, accepting a document. It's like, oh, it looks like a subpoena to me, and you don't know. You're not expected to be forensic scientists or experts in these documents. So when in doubt, contact campus safety or the Vice Chancellor's office. In addition, this law requires that within 72 hours of receiving a notice of inspection, and this is now pertaining to I-9s, okay, so immigration comes, they want to see all the I-9s of every employee that's employed by this district or campus. I don't know if they have separate EIN numbers or not, but anyway, by the employer must post a notice to all employees and provide this notice to any collective bargaining representative. If requested, they have to provide a copy of the notice of inspection to an affected employee. So essentially what's happened is they'll come, they'll ask for the I-9 forms. You are not all in the HR department, so you do not have access to the I-9 form, so you're gonna do what? You're gonna call HR. And once HR is contacted, then the government serves them the notice of inspection. The notice of inspection may contain literally a list, and sometimes, depending on the industry, it can be hundreds, if not thousands of people that they suspect are working without authorization. And so if the employee comes and they're on that list, then the employer must give them a copy of that notice from Immigration Customs Enforcement. This is such a significant departure in terms of what employers were required to do prior. It just adds an extra burden on them to have to do it. I have my personal opinions about this law, but nonetheless, this is what it is. Once the inspection is completed, employers are obligated to provide a copy of the results to any affected employee. So basically, whatever the final outcome was, any substantive violations, technical violations, employees that were required to be terminated because they did not have authorization, and his or her bargaining representative within 72 hours. It is also unlawful for an employer to re-verify the employment eligibility of any employee not permitted by federal employment verification eligibility laws. Now, this is the interesting thing for me is this is already unlawful under federal law. So it's kind of duplicative, but the state, I guess, is making very clear and now assessing its own set of fines, because the federal government has its own fines for employers for violating. And so it's kind of, I'm not sure if in the future when we see this come down, if it ever gets challenged in the courts, if someone's going to make a kind of a double jeopardy challenge. But in my opinion, it's kind of a double penalty for the same violation. But for example, there are employers who, when a person completes an I-9, let's say they present a driver's license and they're a US citizen and that driver's license expires. Well, the purpose of that driver's license was just to verify the identity. They are not to re-verify that person and ask them for an updated driver's license. It's illegal. Same thing with the green card. So somebody who's a lawful permanent resident, their green card expires, an employer is prohibited from re-verifying that person, essentially asking them for the documentation again. So should the employer do so and that becomes known to the state, the employer will be penalized with fines. Sometimes in the federal laws they're found responsible for violating our federal laws. There's also criminal penalties that can be imposed as well. So it's something serious. The question is if the employer has to verify. So by law, on the first day of an employee's, on their first work day, the employer must verify that the individual has legal authorization to work. And that if you remember, and so those of you who have worked in multiple places, they give you like a list. There's list A, there's list B, and there's list C. And you have to either produce a list A document or a B and C document just to verify identity and work authorization. This applies to US citizens, it applies to lawful permanent residents, it applies for people with work permits, temporary visas, etc. So they just have to show that they've got whatever documentation is required that they can work in the United States. Right? There's a lot of employers that, we've had clients in the past that don't even know what an I-9 is, and that's scary. They don't know what an I-9 is, and they're employing people that are already in violation, and that's going to be a major, major fine should they ever be subject to an inspection. So, all right. I'm going to fly through these slides because I don't think it's really relevant, but I just want to mention it because we're now on travel ban 3.0 is what we call it. President Trump has signed executive orders, rescinded parts of it, re-signed to kind of fix the issue. The reason why I want to mention it is because when the first executive order went into effect that banned individuals from returning to the United States, I'm not, excuse me, I'm not talking about US citizens. The places that were most impacted were our colleges and universities and our hospitals and medical facilities. There were a lot of doctors, professors, researchers that happened to be outside the United States when the travel ban came down and there was panic. So the only reason why I want to mention it, this is kind of what exists right now. So it specifically applies to individuals from Iran, Libya, Syria, Yemen, Somalia. Chad just got taken off on Monday, I think. I'm not sure. I haven't even got a chance to read why. I don't have a lot of clients from Chad, North Korea, and Venezuela. So the important piece of this is if there are faculty or employees that are from these countries, they really need to proceed with caution, and I really recommend them seeking legal advice before they travel outside of the United States, because they may very well have problems returning. So that's the only point I want to make about the travel ban. I don't want to go into too much detail. There are some exceptions that allows, there's waivers that can be applied, there's complicated processes that we as practitioners are still trying to understand and figure out how the government is implementing them. Because there's consular posts of the United States throughout the world, and they seem to be applying them differently. So we're still figuring that out. So just to be aware that if you know of individuals from those countries who intend to travel, make sure they're careful or that they seek legal advice. I'm gonna skip all this. Okay, rights and responsibilities. Any questions before I actually go into this next section?
Has there been a response from the state of California regarding the ban on nonprofit groups to give sort of that education or?
It just came out yesterday.
Okay.
Yeah, so I haven't even, I'm not aware, maybe, but it's too soon for me to have even read anything yet.
Yeah.
But yeah, it just came out literally yesterday.
Wow.
Yeah.
The travel ban does not apply to U.S. citizens. Does it apply to green card holders?
The green card holders are an exception, but what people have to understand is anytime a non-U.S. citizen travels outside the United States, regardless if they're a green card or they've got some other type of visa, when they come back, they're basically what we call, they're seeking admission, they're asking for permission. So if Customs and Border Protection have any reason to deny them entry, or they think that they're affiliated with a terrorist group, or they're red flagged, or they've got criminal convictions, they can do so without any basis for appeal or anything. So that's the risk. You want to make sure that there's not going to be, and sometimes it's something as simple as a recent DUI, that the person will come back, sometimes they'll let them in, sometimes they won't, but they will place them immediately in removal proceedings. So it's just a good idea, even if they're a lawful permanent resident, just to have their case assessed to ensure that there's not any kind of red flags that we're aware of, that they can take action to better protect themselves or have documentation that would explain some issue that may come up in their history. So. Okay, so 3 reasons why an immigration officer, ICE agent, again, Immigration Customs Enforcement, may visit your place of work. As I mentioned, they could be conducting an I-9 investigation, and they're there to serve a notice of inspection. It has nothing to do with an individual and employee's, violation immigration history. That's strictly to investigate an employer. They have an arrest warrant or search warrant related to an investigation. They are conducting a workplace raid, and again, this pertains to investigating an employer. That being said, I probably should add a 4th non-official reason, because we probably see that reason happen more than the top 3, and that is they randomly come into conversation with individuals and apprehend people at beaches, for everything, shopping malls, outside of courthouses, college campuses would be no different. We hear a lot of stories, especially in South County, outside elementary schools, middle schools, any place that ICE believes there are undocumented immigrants. And generally, when I'm, again, giving community education presentations, and I'll mention this again in this one too, the individual has a right to remain silent. What usually gets them in trouble is they voluntarily start talking and giving information. Once that information is given to ICE, they're doing their job. They have to apprehend the individual. So someone admits, I don't have papers, I'm here illegally, blah, 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 and they keep talking, that's enough. So they don't have to have a warrant to talk to people. And they often do kind of show up in public places to talk to people, and people talk back and provide them with the evidence and information that they need, that would be sufficient. So I would say that's probably like a non-official reason that ICE can be on campus, but nonetheless, it occurs. I'm going to skip over the I-9 portion. Actually, one thing I want to mention. So, because an I-9 inspection may result in imposition of substantial fines against the employer, this is when, if it's an I-9 inspection notice, you are to contact Guillermo Ramos, the Vice Chancellor of Human Resources, immediately. If you forget, call campus safety. So I can say, like, when in doubt, call campus safety. Campus safety will need to know the nature of the matter and whether it needs to be directed to the President's office, Vice Chancellor's office, what have you. But if it is a notice of inspection, because again, this is related to human resources in terms of hiring and documentation, the best person to contact at this campus would be the Vice Chancellor's office, Guillermo Ramos' office. And you want to make sure that you ask the investigator to wait while you contact human resources. And that doesn't mean that you ask them to wait and you walk away. I know it sounds like babysitting, but you're gonna just want to make sure that they don't begin to wander other places, whether they're non-public or public spaces. So you can try and engage in conversation. They're human beings, they're doing their job. Avoid any conversation about students, employment information, talk about the weather, sports, whatever the case may be, but you want to make sure that you find a place where they can wait and that you're there with them while you're making the phone call to contact Campus Safety and Human Resources, and someone can respond in terms of what the next steps would be. If they do serve a notice of inspection and you are in a place that you're able to forward that documentation to Human Resources or to Campus Safety, please do so immediately, because that documentation is going to determine what next steps need to be taken. Is it a notice of inspection for I-9? It's like, oh no, this is a subpoena. Is it a subpoena? Oh no, this is a warrant. So whatever documentation ICE may have, ask them for you to see it, and then forward it by email, by fax, whatever manner you have available to Human Resources. If you don't have a manner available, you have no equipment or technology in front of you, please make the phone call to those two offices. Do not provide any documentation or information to the investigator without permission from Human Resources, or let the investigator wander through the company or the campus's premises. Be sure to obtain the name and contact information for the investigator and take detailed notes regarding the communication. You just want to document as much as possible. You know, people often ask and, you know, consider, depending on what side of the political spectrum, as if, you know, ICE agents are bad people, and they're not. They're doing their job, and I wouldn't want their job for all the money in the world, because I think they have a very hard job. And so just make sure that you're treating them with respect. We hear the stories of the bad apples, but I think there's bad apples in every profession. It's not even just law enforcement that maybe abuse authority or take matters into their own hands or doing random, you know, unlawful apprehensions, etc. So that's the reason it's important just to document. Know who it is that you're speaking with. If they have a title, ask for their title. One of the tricky things with ICE, and I'll get into it in a minute, is they sometimes come in civilian clothes. So you don't necessarily know that they're an ICE agent. So you want to make sure that you have the ask for their name, have them identify themselves. They have badges. If they don't have, you know, their police uniform on or anything like that. And they both have unmarked cars. So it doesn't necessarily say all the time. Sometimes it does, Immigration Customs Enforcement. So you've got to keep your eye out. Yes?
Don't they have to legally identify themselves as agents if they're looking for information?
Yes and no. It depends on the nature of their visit. So when they're, see, we have to be prepared, right, for all circumstances. So I'm kind of talking more about the fourth circumstance where they're just on campus, randomly, you know, walking around talking to people. They don't need to identify themselves as ICE agents. So they can, you know, continue to come to, and then at the point where, before they can arrest or apprehend someone, they do in fact need to identify themselves as a federal immigration enforcement agent. But prior to that, they don't. But if they're asking for documentation or, you know, for an individual, then yes, they need to identify themselves and they need to have the documentation that gives them that legal authority to request records, documents, search a premises, etc. And we'll talk about the difference between an arrest warrant and a search warrant in a minute. Okay, so how to address ICE agents who visit the campus. Anyone, including ICE agents, can enter public areas of your campus without permission. Okay, so I talked a little bit about what that means. Dining areas, parking lots, lobbies, or waiting areas. They have every right to be there as any other member of the public, student, etc. However, being in a public area does not give ICE the authority to stop, question, or arrest just anyone. Okay? So if you are aware, someone, a student alerts or there's suspicion, I think there's ICE on campus, the most important thing for you to do is to be proactive. Okay, so be alert, okay, pay attention in terms of keeping your eye out for either ICE vehicles, if they're labeled, government vehicles, anyone dressed in law enforcement that doesn't have like a, City of Cyprus police patch or anything like that. So be alert. You want to make sure that you are proactive in terms of engaging with that individual before they, wander beyond the campus. So go up to them, introduce yourself, ask them, the nature of their visit, and see what it is that they need, and that way you can best handle the situation without giving them access and contact with the rest of the student body. No one can enter a private area of a campus or building without permission or a judicial warrant. So again, I'll talk about judicial warrants in a minute, but this is where all of you come into play in terms of permission. So if any of you grant permission to access a private area, that is basically an opportunity for them to inquire, to search, to look, because you've basically given that permission to them. Same thing applies, and if we have time, I can talk about it a little bit, but if ICE goes and visits someone home, or even, law enforcement for that matter, is if the person gives them permission to enter, then they don't need a warrant, because you basically allowed them in, and now they have the right to speak to anybody who happens to be present in that home. Same thing here at a campus. Do not allow ICE agents to enter private areas of the campus. You can say something like, I'm not authorized to give you permission to enter, please wait, and I will contact the campus agent. Simple as that. Just have them wait and make sure you stay with them. Do not interact with ICE agents. If ICE agents have questions or requests, say, please wait a moment while I contact someone who can help you. And when I say do not interact with ICE agents, it doesn't mean like don't speak to them. You just want to make sure that the nature of the interaction, that you're not divulging information that's confidential, any information that could be used either against the school or against any student or any employee. So if you're going to have any interaction with them, again, it's going to be the weather, sports, conversation while you're waiting for campus safety to arrive or human resources. Again, the tip to show that some areas are private, mark them with a private sign, keep the doors closed or locked, and have a policy that visitors and the public cannot enter those areas without permission. In different contexts, in different places, workplaces, I've seen people have sign-in requirements. So at the reception area, they need to sign in so that they know exactly who's here. You have them have a seat, so you contact whoever you need to contact, depending on the nature of their visit. So that's something, I don't know how practical that is in all of the buildings on the campus or areas, but at least the private areas, you're just going to want to make sure that those private areas are well labeled and secure. Yes?
Are classrooms generally considered public areas or private areas?
Yeah, that's a great question. It depends. So, for example, if there's a classroom and if the professor, for example, generally allows people to walk in that are not registered for the class, then the argument can be made it's more of a public space. But when you've got a campus like this, I'm going to assume that you've got students that are registered and the professors probably, or the faculty members probably know who's in their class or who's not. That may not be the case, for the first couple weeks of the semester, but nonetheless, eventually they should know exactly who has paid their fees, registered to be in this class. My advice would be to err on the side of caution and probably close those spaces and not allow anyone without permission. So let's say there's a student that wants to check out the class, so they're not technically registered. So there's a policy in place that basically says classrooms are only made available for students registered for those courses, or if special permission is granted by the faculty member or staff member. But you want to make sure, as staff and faculty, you all, and if there's any staff and faculty here, they represent the school. They represent the campus. So faculty members can't kind of do what they want, and some of them want to take matters into their own hands and say, well, I want to help Immigration Customs Enforcement, or I want my classroom. So there needs to be consistent application of whatever the policy may be. But to the extent that the classroom is closed to the public, no one can just wander in, then it would also apply the same to ICE, that it would be considered a private area. And our faculty and staff need to be aware of when they observe an outsider, and it doesn't have to be an Immigration Customs Enforcement, but there needs to be, again, a consistent policy in terms of how to handle that situation. Professors, perhaps has to stop the class or ask the person their name, can I help you? We're in the middle of session, et cetera, whatever that is, but it should be applied the same across the board, not just to ICE agents. So you need to be consistent to avoid any confusion, and faculty and staff are all subject to the district's policies, protocol, and the resolution. So if people aren't comfortable with the protocol and they're not comfortable with, how should I say, enforcing or implementing the resolution, then my suggestion would be this is probably not the best place for them to work. So they're really, as the employer, as this entity, there needs to be consistent application in how these situations are handled. So kind of a, depends question, answer, but hopefully that answered your question. All right, be prepared if ICE agents visit the campus. So again, I kind of mentioned this already. You want to be alert, keep an eye out for government vehicles, both marked and unmarked. Look for officers dressed in law enforcement uniform. Again, sometimes they be presented in civilian clothes. Be proactive. Approach them as soon as possible for the safety and security of the student body. Inquire about the nature of the visit. Again, do not provide any information or the location of any student or employee they may be inquiring about. If they have a question about a student, you want to immediately contact campus safety. If they have a question about an employee, you want to immediately contact the Vice Chancellor's Office of Human Resources. Be prepared. Have on hand the contact number for campus safety and human resources. If I were you personally, and depending, I don't know what everyone's position is here, but those are probably 2 phone numbers I would make sure you have in your cell phone, because they may not come into the building where you're working, you may be on campus. But I believe that all of you have an affirmative duty to protect the confidentiality, safety, security of students. So you want to make sure you have those telephone numbers readily available to campus safety and to the Vice Chancellor's office. And maybe before the end, we can make those telephone numbers available, so everyone can be clear about what those numbers are. And I'll even give you, a 120-second pause that you can all put them into your phone before we leave. So, and then identify a space for them to wait and stay with them. So that's regardless if it's out in the grass area, whatever. You can walk them to a bench. Or wherever the closest building may be, a lobby, a waiting area that they can wait while you contact campus safety or HR. Okay, immigration agents can enter a private area only, oh wait, we did this already. No, we did, okay, sorry, it's repetitive sometimes. They can enter a private area only if you have your permission or judicial warrant. If agents try to enter a private area, let them know that the area is private and that they are not permitted to enter without a judicial warrant. Ask if they have one, okay? If they have one, you're gonna wanna read it, and you're gonna wanna ask for a copy. They generally do have a copy with them. Confirm the address is correct, okay? Because sometimes they're mistaken as to where they are when it comes to both residences and places of business. And make sure it has a judge's signature. Immediately contact General Ramos or the Vice Chancellor of Human Resources if you receive any warrant or legal document with the judge's signature, or if you're just not sure. Because sometimes subpoenas may be served which don't necessarily have anything to do with immigration, and you're not necessarily equipped to make that determination what type of document it is. So when in doubt, contact, again, you're going to hear me say this 100 times, campus safety or human resources. ICE agents may try to use an administrative warrant to enter. However, an administrative warrant does not allow agents to enter private areas without your permission. Administrative warrants say Department of Homeland Security and are on forms I-200 or I-205. I've got a picture here, and it's really hard to see. But I want to, so you guys kind of get a feel for the difference between what a judicial warrant is and what an administrative warrant is, okay? Administrative warrants, again, do not serve a legal purpose in terms of giving ICE permission to search a premises or to arrest anyone. Only a warrant signed by a judge. So you can see here at the top, it says United States District Court. Okay, so you want to make sure any judicial warrant is going to reference the court that the judge basically belongs to that signed the warrant. Okay, so if you don't see any name of a court, and it would be a federal court, okay, so it's not going to be, Superior Court of Orange County. It's going to be a federal court. Then you automatically know that it's not a judicial warrant. Okay, it has the district it has the name of the individual that's being searched, or the address of the premises. The name of the individual that's being potentially arrested, or if it's a search warrant, it's going to have the address of the place of business that they're given permission to search. The other important thing is that the search warrants have an expiration date. Okay, so it says it gives ICE permission to search a premises by a certain date. So just take a moment. I know it kind of can be nerve-wracking and people get really nervous when they're probably approached by any law enforcement agency. I'm sure there's people that get nervous when campus security comes and approaches them as well. So it does make people nervous. So I imagine if any of you were given a judicial warrant, it's going to probably raise your blood pressure just a little bit. You might be a little bit anxious. Just take a deep breath and just read over the document carefully, okay? Make sure it has the judge's signature, make sure the address is correct, and if it has the name of an individual, and make sure that it's valid, that the warrant is not expired, okay? So just peruse it. You're not going to handle it. You're not going to make a call as to what next steps are going to take. You're not going to respond. You just want to kind of be able to look at it so that when you call campus security or you call human resources, you're able to provide them with some basic information or observations about the document. I believe it's a warrant. It has the district court of, the address is correct, it appears to be valid. You are not making the determination ultimately, but any information that you can use to be able to share with campus safety or with HR, the better. Okay, so just take a moment just to look it over, and you don't need to respond to ICE. You don't say, oh, this isn't valid, sorry, here you go. Just say, okay, thank you, let me make a phone call, and please wait here while I get someone that can assist you.
Can I?
Yes.
I don't want to be a burr in the side, but if you can't reach anyone, security's not picking up, the human resource department isn't picking up.
That's a great question. Arturo, I'm going to direct that one at you. What happens if no one picks up? If nobody answers at campus security, I don't know if does that happen? Or they're not able to get a hold of someone in HR. Maybe it's after hours because there's classes going on in the evening.
Yeah, well, all you have to do is tell them that the protocol is, this has to be approved by either campus safety or human resources. And until that happens, I cannot give you the information, the document. Sorry, you're just gonna have to come back later. That's the protocol. I'm gonna get fired if I don't follow the protocol.
Okay. Did everyone hear that? So essentially what Arturo shared is the protocol is to be followed. And so in the event that ICE is there, you're not able to reach anyone at campus safety, you're not able to reach anyone in human resources, you're simply going to explain to ICE what the protocol is, that you are to contact human resources or campus safety. Unfortunately, I'm not able to reach anyone there, and I'm not able to provide you with any information or documentation without the authorization of campus security or human resources. How they'll respond, I don't know, because there's a lot of different ways that they can respond, but at least you're communicating to them, your job's on the line if you fail to follow the protocol. Let them know, get their contact information so that if and when you are able to reach someone in campus safety, you can ensure them that someone will be in touch with them as soon as possible. That's what I would suggest.
Quick question.
Yes.
And I'm just curious to know if we follow up CHIRLA's advice and the officers are not receptive to that response, is there any individual legal recourse for us, perhaps?
This goes really to this point. So if there's any legal recourse, if ICE basically refuses to comply with what you're saying and not giving access. So if ICE comes with a warrant, and this is the subject under the judicial warrant, or maybe it appears to be valid, or you refuse ICE entry. They ask for entry, maybe they don't even have a warrant, you say no. If they enter anyway, you should continue to refuse consent and document their actions, but do not obstruct their entry. And that's really for your own protection and
We don't want
safety,
anyone to
right?
get
So we're here talking about student safety, employee safety. You are all employees, so you want to be smart. I think the message is clear. You are not to take matters into your own hands. And so don't put your own liberty at risk by obstructing justice, or who knows what charges they could probably file against you. It's not worth it. But you want to make sure that you continue to speak, that you're refusing to give consent. Hopefully you have their name by that point. You document their actions, so figure out a way to take notes. If you have paper pen available on the phone, whatever may need to happen. But do not obstruct their entry. It will only end up problematic for you. Yes?
Could we record their actions with our phones?
That's a great question. I think you can, but I would let them know. So you can say, I'm afraid I'm going to need to record or videotape the action. So you can. I think the question becomes whether or not that recording or video would be admissible. And that's if there's some sort of legal proceeding that ensues. So, yes. But again, you want to be smart and you want to be careful, because we've known people, and it's not just law enforcement, that can become aggressive in the event that they feel that they're being challenged and phones get taken away and knocked out and all sorts of things. So, yes.
This question is for Arturo. Any thoughts about body cam for the officers?
For our officers?
Yeah.
I haven't discussed that with someone, but if it's something that you think would be helpful, I would think that your director should forward the recommendation, and I'd be more than happy to forward it to the chancellor. Okay. And actually, I don't know if it may be, I don't know if it's the president's call or the chancellor's call, but we'll get it to the right person.
Okay.
Okay, so if agents don't have a valid judicial warrant, you have the right to refuse them entry. If the arrest warrant appears valid, ICE can arrest the named person if he or she is found in the public areas of the campus. Okay, so this is an important point. This is specifically speaking of, I want to distinguish here, making sure everyone's catching this. Here I'm speaking of arrest warrants. Right here I'm going to be speaking about search warrants, and there's a difference. Okay, so if they have an arrest warrant and it's valid, and that person they successfully identified, you are not able, legally in the state of California, to assist them in identifying that person. Okay, but if they have the warrant and that person, because oftentimes they have the photo identity of that person, they have a photograph, or they've been following them. Sometimes they follow them from home to their place of work, to whatever public space may be. They have the right to arrest that person. There's nothing campus safety, any employee, person can do to prevent that from happening. Okay, that's a completely legal arrest. However, an arrest warrant does not allow ICE to enter private areas in order to carry out the arrest. Okay, so you still have every right. An arrest warrant is not a search warrant. A search warrant gives ICE access to a specific space. If it's not a search warrant, then they are still not permitted to access those private areas. So just to give you an example, and I'm not saying that this is the case, but let's say, for example, there was a student in someone's office, and ICE has an arrest warrant, and the office is a private area, financial aid, I don't know, student services. You are under, not only are you not under obligation to direct or take ICE to that individual, you are prohibited by California state law to do so. You would be assisting in the enforcement of immigration law. Okay, so if the student or the individual, could be an employee for that matter, is in a private area, you still have every right to deny, right, permission to enter that private space. The only way ICE can enter a private area is with a search warrant. Okay, so understand the difference between, is it an arrest warrant for a person or is it a search warrant for a place? And the warrants will specify which one it is.
So instructor office is considered private?
I don't know. Is an instructor's office considered private?
Yeah.
I would hope so.
Let me,
I mean, it depends. This is kind of the same thing as a classroom. I would assume yes. But there are some campuses and some schools that have a very open door policy that those offices are essentially accessible to anyone. I don't know on this campus if that's the case.
yeah, generally your office, and again, it sort of depends on how you treat your office, but generally speaking, it is a private space because, you know, a student couldn't just walk in your office, right? Another employee could, other than maybe your supervisor or campus safety or someone who's authorized, cannot just walk into your office. But again, to make it more clear, you need to make sure that it's clear that the rules in your department or your building are that, you know, that these are private spaces. Because if you create the impression that they're public spaces by leaving them open all the time and letting anyone walk in, then it gets a little bit muddier.
I think that's a great point. I just want to make sure for the purposes of the video and anyone who may watch this in the future, does your voice get picked up by the camera or do I need, okay, great. I just want to make sure. I can repeat it. Go ahead.
It's interesting about the classroom and office spaces because I'm a faculty at NOCCCD with the ESL department, and then you have this open entry and exit policy where students can come in any time and students can leave anytime, especially with the non-credit segment of that, the ESL department. So, you know, I'll be teaching class and then you have a student walking in, you know, but they have to enter the classroom for us to verify their registration, right? And that can be any time during the semester. So this is where it gets a little bit confusing. So if you open the door and you say, okay, you know, student X, who is now registering halfway through the semester, walks in to let you know that they're registered, and then, you know, they're not always carrying that piece of paper, right? So, you know, then you have ICE agent B walking in, right? And so it becomes really kind of, and like you said, it has to be an institutional and a divisional kind of understanding on what happens, you know, because it gets really complicated when you have to leave your door, you know, if your door is open and students are walking in and out, you know.
I don't know how practical this is, but a suggestion that I have known other schools to adopt is to have literally, anytime the registration changes, a student is added, a student's dropped, essentially there's a sign-in sheet for those students upon entry that they need to sign to acknowledge their presence, and then that way you know that if there's anybody that's not signing, that they're not registered. I don't know practically if that would work for that particular, because I just can imagine the influx.
It's pretty chaotic.
Yeah. We work with a lot of clients that we can't even keep up with phone numbers and addresses sometimes because they're so fluid in terms of movement.
But as soon as you open that door and let someone in, say there's an ICE office on campus, they're walking down the hallway, your classroom door is open, as in not locked, but closed. They open the door and they step inside. And if we we acknowledge their presence and say, excuse me, what do you need? And they continue walking in, is that construed as them doing something illegal and entering a private space?
Well, no, because I think really it's very much a gray area. I think the argument can be both ways, whether it's a private or a public space. I think, again, this is going to rely more on being alert and being proactive and doing, I mean, you can't possibly, you're not private investigators, you can't possibly ascertain, oh, that person looks like an ICE official, because you don't know. So I think it's really, and it's just a matter of being smart in how you handle any perceived guest. And again, being consistent, right? You don't want to discriminate any perceived guest that someone appears not to be registered or a part of, they could be lost. I mean, people today, I popped into another number of places. Does anyone know what, CCC Plex is? So they could be lost. You don't know, but I think to the extent that you can inquire and be proactive, the better. But again, I think it's a bit of a gray area. Were you going to say something?
Is there anything in district policy that guards against the unauthorized access of the spaces used for instruction? That is to say, if that person, an ICE agent, is not registered for the class, then they are not allowed to be there according to district policy.
Yeah, I'm not well versed in district policy, just the resolution. Arturo, can you speak to that?
Yeah, I don't think there is, but absent an actual policy on that, the best advice from the district is if you're an instructor and class has started, anyone who comes into the classroom that is not enrolled or attempting to enroll, you have the right to tell them, I do not allow any interruptions in my class once we've started, and I don't allow people to sit in my class without special permission for me. So anyone, regardless if it's an ICE agent or anyone else, if they walk in your class and you've already started class, you have the right to say, I'm sorry, but you're interrupting my class. I don't allow anyone in unless they're students who are trying to enroll, or I've already given permission. And then at that point, they're on notice that they're not allowed in.
Yeah, and I would say if that was the protocol that was followed, then I think that would constitute a private space.
I, in my mind here, and I wrote a little note to create a little sign that says to put outside on the window, restricted area, enrolled students only allowed. It's
To the
just a
extent
small
that that's
sign.
feasible, it's, again, it's just another way you can be proactive in establishing the private versus public space, yeah.
If an agent comes on campus with a search warrant and it's been verified that they're at their right address, 9200 Valley View, does that allow them to go into any building, including counselor's office and with the students?
So generally, I'm trying to think, because I don't think I've seen a search warrant for a campus before. Usually like an employer is like one building, it's a place of business is one, but you have one address for multiple. So generally the search warrant though not only specifies the address, it specifies what it is that ICE can search. So whether it's electronic devices, whether it's specific offices, whether it's, it's got to be specific. So it doesn't, just because it has the address, it never just has the address. It doesn't say, oh, they can search anywhere they want to, at this address on this campus. It's generally specific in terms of not just the address, but the nature of the search and what it is that ICE is being given permission to search. So it could be a particular, office space, a particular person that might, be in violation of the law, et cetera. But the search warrant typically spells that out. Okay, so speaking of search warrants, so I think I mentioned this already, but that the arrest warrant does not allow ICE to enter private areas in order to carry out the arrest. If a search warrant is presented, you want to make sure to check the information is correct and it's valid. The judicial search warrants allow ICE to enter the non-public areas of campus. Again, this goes specifically to what the search warrant lays out. And again, if it does not appear valid, you may refuse ICE entry. If they do not listen to you and they continue to enter anyway, continue to refuse consent and document their actions, but do not obstruct their entry. Now this is what an administrative warrant looks like. Okay, so it's going to say, this is a really old one. In fact, let's see if I've got anyone here. Yes, I'll circulate this sample if any of you are interested in seeing it. I didn't realize this is Department of Justice. It says Department of Homeland Security, warrant for arrest of alien. And then it basically is a document that establishes an individual is removable or deportable from the United States. Okay, so any federal immigration agent can utilize this form to be able to establish a basis on which to arrest someone, but it does not hold the same legal weight as a judicial warrant, okay? So the administrative warrants, there's these forms I-200 and I-205. You'll find the form number in the bottom corner. They're administrative documents that identify an individual suspected of being subject to deportation and authorize designated immigration agents to take the identified person into custody. They don't hold any legal weight, okay? So if ICE presents this document and tries to pull it off as a judicial warrant, it is completely invalid. It has no legal weight whatsoever. There is nothing that you need to do in terms of giving them access, giving them permission, identifying the person, helping them locate the person. In fact, if you were to do so, again, you would be in violation of our state laws. Okay, so just so you can see physically what the difference looks like, we'll go ahead and pass that around. The documents, the administrative warrants, are not reviewed or issued by a court or a judicial officer. They do not give ICE the authority to enter the non-public areas of the campus. You may continue to deny ICE access to these areas. This warrant is directed at federal immigration officers, not local law enforcement. So federal regulations only provide authority to ICE agents to execute an immigration warrant. So this is just essentially what gives them permission to arrest someone. And typically, though, what you'll find is it will be out in public spaces. Like I said, they may not have an arrest warrant signed, but if they have an administrative warrant and they're following the person from their work, from their home, and they end up here on campus, the person's in a public area, ICE can arrest that person with that documentation. However, you, in terms of the representative of the campus, this document serves absolutely no purpose. So it's just important to understand the difference.
Question?
Yes.
In that scenario that you just presented, let's say that an ICE agent observes the person that they're following leave a public space and come behind the counter to a private or restricted area. Can we stop them from getting access to that restricted area to make the arrest?
Absolutely. Yeah, absolutely. Without a
And by
judicial
stop, I simply mean tell them that we refuse to allow them in. I'm not going to physically step in and stop them.
Absolutely, yes. You can continue to deny them access to any private area. The only time you cannot is if they have a judicial search warrant, specifically. That is the only incident where ICE can access private areas. Otherwise, without that, under no circumstances, unless you give them permission, can they access private areas.
Does having a search warrant also authorize them to access our student information system?
Only if the search warrant specifies in the search warrant what they're allowed to have access to. Yes, and if it does spell that out, then unfortunately you will need to comply.
So that would mean that I would have to physically sit at my workstation, give them my password?
No, absolutely not. You would call human resources and campus safety. That's what you would do. You do not, even though the search warrant says, even if it said, access Lisa D. Ramirez's computer located at, this is building, I'm not going to put a password, I'm not going to log in, I'm going to call immediately campus safety, HR, they're going to need to speak with the attorney, okay, because now when there's subpoenas, when there's warrants involved, you need legal counsel to provide you advice depending on the circumstances. That's their job, not your job. But you are to take no step, no action to comply with any legal document, subpoena, warrant, order at all without the direction, I guess, of campus safety or HR. If they do not give you permission to do that, do not do anything other than make that phone call. All right, which is a great segue into, again, you've heard me say this probably too many times, but we're going to repeat it again. The protocol of the district is that anyone approached by an immigration official regarding a student, okay, should contact campus safety. Campus safety and the president's office will determine how to respond. If ICE has questions about an employee, immediately contact the Vice Chancellor of Human Resources. Do not take matters into your own hands. Do not share documentation, information, provide access to private areas, or direct them to the location of the person of interest. If ICE presents a warrant, immediately forward the warrant to the Vice Chancellor of Human Resources. This may actually be a good time to maybe provide the phone numbers. I don't have them, so I don't know if there's someone from Campus Safety that can provide the telephone number where everyone can just take a moment to make note. And if we get the phone number for the Vice Chancellor's office as well, that way we keep telling you to call them, but unless you have the phone number, it kind of makes the presentation pointless.
The number for HR is 714-808-4826.
Can we repeat it one more time?
The number for HR, or this is the general number, is 714-808-4826. Does anyone have campus safety?
Campus safety phone number is 714-484-7387.
Okay, can I ask you a question? Is that phone number for all the campuses or specific to this campus?
Specific to Cypress College.
Is everyone here from Cypress?
Yes.
No. Okay. Do we have other campus security, campus safety numbers? 714? Okay, and that's for which campus? Fullerton. And is there anybody here from the? Is there anyone here from the district campus?
And I have campus safety number is 714-808-4919.
We need to just put those on.
Yeah.
Okay, I wish I had a dry erase marker because I would just write them up on the board. Anyone? Okay, yes.
I had a question about, campus safety's open 24/7.
Yeah.
Open 24/7, so what happens when HR office is closed?
Yeah, so again, kind of reiterating what Arturo had said before. You get campus safety. Campus safety is going to be, oh, you are campus safety. Oh, you're campus safety and you can't.
An ICE agent at 8 o'clock at night. You do have students that are really
Right.
and we're campus safety. I can't run anybody. I don't have access to run students or anything like that. Say it's legit or all that stuff. I can't get all the way up that HR number, so one of my kids are calling.
Right, so there needs to be a chain of command, and I'm not sure what that chain of command is. So Arturo, did you hear the question? So if campus safety is contacted, right, because they're here essentially 24/7 or I don't know, close to 24/7. If they cannot get a hold of someone, HR is closed, who are they to contact? Is there a number for campus safety in the event that it's after hours that they could call essentially an emergency? This would constitute an emergency.
We'll have to find what number to use. I don't know.
What's your number?
Yeah, my home number. Well, we may actually have to give somebody's home number, whether it be Edamar or myself. But let me find that out. But the other way to deal with it is if they come to you and you're comfortable that it's a valid warrant, right? And they can get access. You can give them access. That's one thing. But if you have any doubts and you'd rather HR or our attorneys check it out, you can simply tell them our protocol is that if there's concerns that I have or if there's an actual warrant, this has to be reviewed by our attorney, and the attorney won't be in until tomorrow morning, so why don't you just come back tomorrow morning? The majority of these instances is not going to be an emergency. So the question, I guess, would be if they claim there's an emergency, which would be pretty rare. I don't know, maybe I should ask you that. How would you recommend we handle it? Because if it's not an emergency.
I'll just tell you experientially, ICE agents don't work after hours. So I don't know, I'm just trying to think if I know of an instance that I've even heard of that they have come with a warrant or, it's typically very early in the morning, sometimes like 5 o'clock in the morning. They'll visit residences or places of business or what have you, which then you can say, wait until 8 o'clock or whenever, the HR department opens. But I think it's gonna be extremely unusual for ICE to be here at 8 o'clock, 9 o'clock, again at night. And the only urgency really is if they do in fact have a warrant signed by a judge that you need to be able to confirm.
Because we do have night classes until 10:30, so if they're actually following a student to the campus on weekends also, and they do have a warrant stuff.
Yeah, and again, just remember, if they have a warrant to arrest someone, they can do so in any public place on this campus, and there's nothing you can do about it. There really isn't. But it's really a matter of when that student enters a private area, say they get inside the classroom, that at that point, you're contacted, right? I was saying, professor, the faculty member teaching that class, said, whoa, this person just followed another student in, they're an ICE agent. My job is to have them wait. I'm going to contact you. And then really your job is they can't utilize, even if they have that arrest warrant, they can't exercise that arrest warrant. It will be, even if they ignore you and physically arrest that person, that arrest will be deemed invalid. It's an illegal arrest. So your job would really just to be able to explain this is a private area. We cannot give you permission to enter this space. And they can choose to wait outside. And then the crazy question really becomes, and I don't want to go into really crazy conversations, is will the campus be willing to allow that student to stay in the private space for a lengthy period of time? Arturo?
Yeah, and again, I just wanted to reiterate what you said already, which is, if they have an arrest warrant, that doesn't give them the right to go into a private space,
Right.
because they need a search warrant for that. Now, if they come to you with an arrest warrant, they say, John Doe, we know they're enrolled here, and they ask you, what classroom are they in? You have no legal obligation, in fact, you're legally obligated not to help them with that, even though they have a valid arrest warrant. Now, if they know what class John Doe is in and they go out and wait outside, my guess is there's probably nothing we can do about that.
There's nothing. No. But the question just becomes, only because this has come up in other contexts, I've not ever had or heard it come up in a college campus, but where ICE does follow someone and they enter a private space, a residence, for example, or a church, then would the district allow that student to remain in the private space indefinitely until some confirmation can be made that ICE is departed?
That's a really good question. I'd like to know what the response would be.
I'm sorry?
So will the district allow that student to stay within a private space for an unlimited amount of time until they can actually find, right?
That's a question. I mean,
That's excellent.
I'd have to ask, but my guess is there's a couple of questions. One, once the classroom is over, it's not as private as it was before, is one issue. The other issue is the reality is unless we're providing toiletries and food, the person's going to leave eventually. But in terms of, let's say, the person says, I want to, you lock the door, I want to spend the night. I don't know. We'd have to find out. That's a good question.
To your point about the class being over.
Okay, the last point that I just want to make, yes. Oh, I'm sorry.
To Arturo's point about the class being over and the space no longer being as private, I would contend that if you lock the door,
Yeah, absolutely.
it is still private.
I think so, yeah. I mean, I think there's still an argument there.
Yeah. Absolutely. Yeah, I don't want to get us too sidetracked. I feel like back in my law school and hypothetical situation that will probably not arise, but obviously you want to be prepared in the event that they do. So the last point that I want to mention, because I know we're coming close to our end of time, is the last reason that I had mentioned from the very beginning, the three main reasons why ICE can come on campus. There's that fourth unofficial reason, but is if they're there to do an ICE workplace raid. And again, their method in which they operate for these types of raids are your traditional criminal investigative techniques. They're really investigating an employer. Sometimes what prompts a raid is an I-9 investigation, so where there's just egregious violation of our federal immigration laws. There are, a lot of people that are there that they're aware of that do not have work authorization, employers never had, complete I-9s, documents are fraudulent, etc. So they have some sort of a lead typically that gives them the information and evidence after many months of investigation. So this is kind of more like an operation. It's very sophisticated, well orchestrated, that ICE comes onto a workplace or a campus. I have never heard of ICE conducting a raid, again, at any public institution at all whatsoever. And generally because our public institutions are generally compliant with laws. I mean, that's just the bottom line. But certainly this can happen in other private places of business. So descriptions of items that can be searched and seized. They will have an extensive list of all of the things that and again, this also are items that could be included in a judicial search warrant as well. So everything from employee identification documents, payroll records, I-9 forms, SSA documents, bank records, showing payroll, cash ledgers. There's a whole list of things that they can be given access to search, including records or information, includes evidence, whatever form, and by whatever means created or stored, including any electrical, electronic, magnetic form, hard disk, zip disk, CD-ROMs, optical disk, backup tapes, etc. So again, they generally have the search warrant already signed when they're conducting a raid, and it outlines exactly what they're able to confiscate and what they're able to search. Armed agents generally surround the premises. You'll be very clear that a raid is taking place. They basically seal all exits and routes of escape, including parking lot exits, building exits. The supervising agent serves a search warrant on either a receptionist or other company representative, alerts other agents via radio transmitter that entry has been made, thus allowing their entry. So the moment that a search warrant is served, then basically ICE in full force could potentially, depending on the severity of the situation, could come on campus. While some agents are questioning employees, others are going through drawers and file cabinets, using documents and computer-related equipment. Once an employee admits alienage, basically they admit to not being a U.S. citizen, the burden shifts to the employee to demonstrate legal status in the United States. And oftentimes, it's kind of like a roundup situation. They will apprehend a large number of individuals. And this is typically, again, we're talking about employees, not students. Okay, so this would be in the context of employees. Sometimes employees do not have their immigration documents with them. Human resources personnel can retrieve copies of the documents from the I-9 files. A family can be contacted to bring the original documents to the company. ICE agents not only interrogate employees, they also attempt to interrogate company representatives regarding immigration policies and practices. ICE agents leave an inventory of property seized with people that have been arrested. A copy of this inventory is archived with the court that issued the warrant. And ICE agents arrest employees who cannot prove legal status and take them to various detention centers. If ICE comes ever to conduct any sort of a raid, it's important that everyone stay calm, no one takes off running. They'll be the first people that ICE goes after. You do not have to answer any questions or volunteer any information. It's generally people who begin speaking that gets them in trouble. Immediately contact campus safety, and then the individual has the right to contact their attorney. So if students or employees have contact with the immigration officer, again, they have the right to remain silent. They are not obligated to answer any questions, including place of birth or immigration status. This is more information that you guys can take with you to share with the student body in the event. I know that Public Law Center, are they coming today?
No, they're not.
No, okay. They did a presentation really for the student body last month. So again, there's a lot of community education presentations, and this is some of the information that's shared. If they're asked, give a real name, don't give a fake name, don't show any false documents. They're not obligated to sign any documents, specifically in order of voluntary departure, without speaking to an attorney. All right, I'm going to skip this in the interest of time. It's just more, again, these are kind of slides that we incorporate into our community education presentation. Sometimes if I have time, I just usually share it in the event that it's useful for you to share with the community at large. I'm going to skip all this. If there's any questions that anybody has about anything we've spoken about.
I have a question. Oh, go ahead, and then.
So no, ladies first.
contention right now is with the sanctuary city, with the board of supervisors, Orange County Board of Supervisors voting against sanctuary city. That can create a lot of confusion with, who to be, the county is complying with federal law or supporting federal law, and then you have the state, and you have all these conflicting information. So my question is, how does one react to this? How does one deal with this kind of situation where there's so much information, you have sound bites of information coming through, and as law enforcement, as campus safety, in Orange County, say supposing they're coming up on the 16th, they're having a meeting, Board of Supervisors, to decide on this issue. So what's going to happen, what's the compliance situation with that?
So, as a basic kind of, Civics 101, I think everyone probably here knows, federal law trumps state law trumps county ordinances and policies, and then obviously county trumps city and local ordinances. So the debate right now is really at every level in terms of the federal government is accusing the state of basically being in violation of federal law. My personal opinion, evaluation, I don't think there's a legal basis for it because there's nothing that affirmatively obligates state agents to enforce immigration law, so we're just choosing not to. And it doesn't mean that we are preventing the federal government from doing its job within our state. It's not like we're keeping them out in any way, shape, or form. When Governor Brown, it was in October, the day he signed the bill, the Department of Homeland Security came out with a scathing press release that basically said, because of this new, law of California, they're essentially left with no other choice than to increase resources in California and to conduct random raids. Okay, so what we are seeing and what they have indicated even more recently is a 400% increase in enforcement efforts throughout the country, but a big focus of that is in states where there's large immigrant populations, California being one of them, and I would say even probably more specifically, Southern California. So every day in the news, we're hearing, workplace raids or workplace enforcement, random raids, apprehensions, detentions. We've got clients that go to their citizenship, interview and they're being arrested and detained from there. So enforcement is definitely a priority right now, and I would say with a vengeance in the sense that it's almost careless. We've completely done away with civil behavior and due process, and sometimes there's U.S. citizens that are basically caught up in these enforcement efforts that is particularly challenging. With regard, so we've got the Department of Justice that's now filed this lawsuit against the state of California challenging the SB 54 law that I talked about, the sanctuary bill. However, within the state of California, what we have to understand is cities like Los Alamitos, I believe it was Aliso Viejo, Yorba Linda, our own county board of supervisors, they're passing resolutions. Resolutions don't have any legal effect. So in some senses, it's really just a declaration of the position of that particular governing body. So these to me are far more political in nature than they are legal in nature. It's to make a statement. And they're effective, right? They're very effective in terms of increasing the fear, the concern, the anxiety in our community. I do community education presentations all the time. I work cooperatively with a number of nonprofits, with the Mexican consulate, and I will tell you the trend that we've begun to see is immigrants, the people that would most directly benefit from the information, are no longer coming. It's the U.S. citizens and lawful permanent residents, family members and friends that are showing up, they're taking notes so that they can go back. Everyone is terrified. Even going to places like churches. You think, same place going to schools where their kids go to school. Nobody is really willing to take any risk right now, and it sent a huge message. So in terms of those resolutions and those local actions that are being taken, it has absolutely no bearing on anything we talked about. Okay, these are just political statements that are being declared very loudly and repeated in the media. They serve a purpose, they certainly have impact. But legally, they're not binding, they're not anything that's going to deter. What's going to impact is, the Ninth Circuit Court decision, the District Court's decision, when lawsuits ensue from some of these policies and legislation. Yes?
Has the law been repealed or removed that Bill Clinton signed in 1996 authorizing local law enforcement to assist ICE agents? Has that been repealed?
It has not been repealed. So that is that 287G program that I mentioned at the very beginning. That's basically when it was created. So it hasn't been appealed. It exists in other parts of the country. However, in the state of California, it's illegal for any agency to enter into that.
So essentially, the state is trying to nullify a federal law. Is that what it's happening?
No, because the federal law, what we have to be very clear about, the federal law does not require or obligate. It creates an opportunity. And the opportunity is, should a local agency or state choose to, the federal government is willing to give funding for the training of those law enforcement agents to enforce immigration laws. It's really the opportunity, it's not an obligation. So what the state of California, through this legislation, has made clear, thank you, but we're not interested, and we're basically making sure that there's no public agency throughout our state that is going to opt into participating into that program.
Yeah, and to add to that, I think it's very important for people to understand that the reason that law is written the way it is, a federal law that says you can, but you're not obligated to, right, is because in the 80s there were a whole series of lawsuits where there were joint operations by local police and immigration officials. And the result of those raids and the lawsuits was basically that the courts agreed with the folks filing the lawsuits that the principle of federal preemption is very clear, that certain areas like immigration only can be enforced by federal agents. And it is in fact illegal for a local law enforcement officer to enforce federal immigration laws unless they're under that very specific program. So unless they're under that specific program, which is one that you can enter by choice, it would be unlawful it would be constitutionally unlawful for any local law enforcement officer to enforce any federal immigration law. Sort of like banking. States cannot issue their own money. They're federally preempted from doing that. Only the federal government can do that. And only the federal government can enforce immigration laws.
All right, well, I want to thank you for your time.